All right, welcome to Lunch with Legal. This is our second Lunch with Legal event today. We're so excited to have you all on the webinar with us. My name is Tillman Heyer. I'm a partner here at Heyer Gutierrez LLP. I'm joined here with our associate Michelle Breitmeyer and my partner Marcy Gutierrez. If you've been at our first Lunch with Legal event, you are familiar with what this is about. What we want to do is just summarize the most important, most recent OAH cases in just a quick lunchtime webinar so that you get the most important takeaways that you need to know about these issues today. We have actually a lot of interesting cases that came out in the last couple of months. We're going to talk about concepts like LRE and child find that I know you all are working with on a day-to-day basis. So a little about us, Heyer Gutierrez LLP, we opened about a year and a half ago, but Marcy and I have lots of experience in providing legal counsel to schools. Michelle also has a long background in teaching and education administration as well. We love working with school districts all across the state, and we provide support primarily in special education, but in a number of other areas as well for our school districts. So let's get started here. We've got 18 decisions from the last 2 months, and so we decided instead of going over all 18 decisions in 30 minutes, we are going to pick and choose the most important, the most compelling ones for you to know. So the first one here that I'm going to talk about is a very interesting case, Parents versus Los Alamitos. And so this involved a 19-year-old student. She had graduated from Los Alamitos. At the time of the hearing, she was attending George Washington University, and she never had an IEP from Los Alamitos. And this student had a lot of strengths. One of them was a high cognitive ability, great academics. Of course, she got into George Washington. But she also had a number of social emotional struggles. So in 9th grade, the student had a residential treatment which was not done educationally, not done through an IEP. In 9th grade, the student had a residential treatment for an eating disorder. She walked out of 2 centers. She was in an involuntary hold for several weeks, and then another residential placement. She walked out of that. She was hospitalized, more hospitalization. And so this was all in 9th grade, which was the 2020-2021 school year. So this student was a student that really had really profound struggles in that school year and ongoing struggles as well. But the academics remained strong. And so in February of 2022, Los Alamitos assessed the student, found the student did not qualify. There were some IE requests. There was very contentious relationship between Los Alamitos and the parent. There was another assessment plan offered in September of 2023. The decision says that the parent became heated because she wanted the student to be qualified just on the basis of the IE alone. In January 2024, the IEP team did not find the student eligible, and then she graduated at the end of the 23-24 school year. So there were a couple issues here, and there was also a very interesting dynamic that the parent represented the student, but the parent was herself an attorney that practices education law. And so first, the parent alleged that there was an issue with the statute of limitations. And so you can only, generally speaking, you can only go back 2 years in due process complaints, but you can go back more than 2 years if the district has misrepresented something or has withheld information. And so the parent argued that failure to offer the assessment plan warranted going beyond the statute of limitations. So OAH rejected that argument and said that that was not considered withholding information. So going to the main part of the decision, the eligibility argument. So OAH found that Los Alamitos prevailed in all areas and found that there was no qualification for an IEP here. So the student really had a lot of strengths at school, and it was interesting to read the decision as well because the student herself testified, and she herself testified that she needed an IEP. So the parent said the student needed an IEP. Of course, the student said that as well, and the student's expert did as well. So what did Los Alamitos prove with only its staff testifying in support to show that the student actually did not qualify for an IEP? And so what Los Alamitos established, what the decision says, is that the student actually did really well in school. She participated, she had friends. There weren't any notable social emotional impacts. Minimal was the word the decision used. So Los Alamitos had a Section 504 plan for the student, but for example, they know the decision says she was a leader in advanced placement English. She did not get stuck. One of the teachers, the English teacher, had no concerns with the ability to access the curriculum. And then on the other side, for example, you had the students' experts that were under the impression that the student had failing grades, which was just simply not true. And so that and other things were what led the judge to discount the weight of their testimony, the credibility of students' experts. There was no maladaptive behavior at school. The tardies or absences were somewhat elevated, but it didn't really impact the student, the decision found. And so this was a child find case in a eligibility case decided in favor of the District of Los Alamitos. And so they looked at the balance of things. They looked at the student's performance in school, and they found that despite perhaps some social emotional concerns and this really profound history of really serious eating disorder and residential placement in 9th grade, that the student did not require an IEP in high school. So moving on to our next case here, Student versus Monrovia. And this case too, I mean, this case I think is probably the first and only case that I've read where OAH says that the least restrictive environment is placement in the home. And so if you're familiar with LRE, you know LRE is about your exposure to typical peers. And the most restrictive placement is the home, because in the home, there are no peers. The student is by themselves. And so this was a 14 to 15-year-old student. The student's birthday happened during the hearing. Student was in 9th grade. The student met the eligibility criteria of autism, specific learning disability because of a processing disorder, speech and language impairment, as well as OHI for ADHD. And the student had been in a home-based program since the 2018-19 school year. So from 2nd grade up and through 9th grade, the student had not attended school in person. And from as far as I can read in the decision, there wasn't a physical health condition that impacted the student. In terms of the student's functioning, the assessment showed that the general intellectual ability was well below average. Fluid reasoning skills and short-term working memory was also below average. Auditory processing was poor. So the student had, and also there were behavioral concerns primarily with distractibility, with impulsivity, but then also aggression as well. And so if we look at the student's home program in the 24-25 school year, the decision never quite made it clear to me whether this home program was something that was done through an IEP. I presume if it was there for 7 years, it was done through the IEP, but possibly it could have been done through settlement or something like that. But the home program that the decision described, the student got 2.5 hours of instruction times 4 days a week. The parent in her home had a quote unquote home classroom, which was a separate a room that was sort of set up as a quasi classroom. There was a one-to-one behavior aid in the home, BCBA supervision. The student also then received OT, speech and language, vision therapy, counseling, social skill services, AT support, adaptive PE, and quote unquote other lessons such as art. It's not clear how much of this to me was through the IEP and how much of it was provided outside of the IEP, but in any event, the student had a broad variety of services. So in the 24-25 school year, Monrovia conducted a triennial assessment. And so after that, of course, they had a meeting and they offered placement, and Monrovia decided at this point that this home placement was too restricted for a student. They wanted to bring the student back to one of their comprehensive sites. So the student, the Monrovia offers SDC placement. It offered a placement that had about 65% placement in special education. The student would be in SDC for core academics, so math, English, social studies, and science. And then the student would be in gen ed for one elective period for PE and then for lunch and recess, of course. Monrovia also offered behavior intervention services, 2,000 minutes a week of one-to-one intensive individual one-to-one aid support, speech and language services, 1 hour a week of behavior intervention services, 1 hour a week of speech and language services, 30 minutes a month of consultation for speech and language, OT once a week for 2 30-minute sessions, 1 hour per week of OT. Monrovia also offered specialized vision services, 2,000 minutes a year, as well as adaptive PE, and also weekly individual counseling. So you have a lot of the same elements in the home program that were offered in the less restrictive comprehensive site. Also keep in mind, right, the student's in 9th grade, so you really are at an older age where you probably should, I think actually with the newest ed codes, the team should have thought about transition as well. So the student actually prevailed. OAH found, almost shockingly to me, that the home environment was the least restrictive setting, was the appropriate setting. And the key quote here is that a classroom with other students would have been too challenging. OAH also said that the IEP team members for Monrovia had limited knowledge of student, and just 2 of the IEP team members that had made the offer had met the student, and even those providers had limited interactions with student. It was an AT provider and an APE teacher. Those were the only 2 team members that had actually met the student. Also, the triennial assessment that was done at the end of 24-25 was done by an NPA, and the assessors actually did not testify at the hearing. So Monrovia was defending an IEP where the assessment on which that IEP was on, the assessors did not testify. And so OAH ultimately found the home environment was the appropriate setting. Monrovia also should have developed an appropriate transition plan. So not post-secondary transition, but transition from the home to the comprehensive school environment. And OAH also found Monrovia should have offered ESY. And again, I'm really surprised to read the outcome in this decision here. You think about high school education, the transition plan requirements, how central that is to the IDEA. I really struggle to see how that can be supported in the home setting versus a comprehensive site. The home setting is just so restrictive, but this is really a fascinating case. If you have situations that involve a request for home placement, if you have anything like a request for placement in such a restrictive setting, to me, this is one of the first, maybe the only case I've heard of where a home setting has been found appropriate for a student that does not have any physical health challenges. So we're going to go on now to our next case involving Ojai. I'm going to kick it over to one of my colleagues to discuss this case.
Good afternoon, everyone. My name is Michelle, and I'm an associate attorney here at Hire Gutierrez. I'm going to go through 3 cases with you, 2 of them from November and 1 from December. The first case comes to us from Ojai. It's a consolidated case, so there are parent and district filed issues. At the time the hearing started, the student was 16 years old and he was in the 10th grade. She was in the 10th grade. This case had a lot of background information from 2023, but not so much before that. So in 2023, the student was placed on home hospital instruction through a 504 plan. The district did an evaluation and qualified the student, and she was placed at the only high school in person in the district for the start of her 9th grade year for 2024 and 2025. On the second day of 9th grade, the student had her first experience of school refusal. She refused to exit her car at drop-off. The student continued to refuse to attend school from that point on. So the parent requested and provided documentation that the student should be placed on home hospital instruction. At her initial IEP meeting shortly after the start of the school year, the district offered home hospital instruction with special education and mental health supports for the student. In addition to that offer, the student was receiving a lot of mental health support from several outside support people, mental health therapists that came to her home to provide support. Over the course of at least 4 IEP meetings during that school year, the district offered 1 hour per month of in-person counseling to slowly begin integrating the student back into on-campus learning. That offer was actually supported by all of students' outside mental health staff who shared that the student should be reintegrated into on-campus learning, but in a slow and gradual process. However, the parent did not believe that student was actually ready for this on-campus time and shared that even when driving past the campus, student felt a lot of anxiety and parent was not sure that student could handle the 1 hour per month of in-person counseling. So in the complaint, the parents shared that Ojai should have recognized this and offered online counseling instead of the in-person counseling. During the hearing, the ALJ considered testimony and evidence regarding the student's ability to attend the 1 hour per month of in-person mental health counseling. And they actually determined that the information provided to them at the 4 IEP meetings from all the mental health therapists and the team showed that 1 hour per month of in-person group counseling was appropriate and provided student with a necessary opportunity to balance her anxiety with her access to peers in a controlled therapeutic environment. On the next slide, there was a second argument in this case where the parent argued that the 5 hours Ojai offered per week of home hospital instruction was not sufficient, even though academically the student they were performing appropriately above grade level in some areas and making appropriate progress. During those 4 IEP meetings, the parent requested more home hospital hours to catch student up and allow her to graduate high school on time. The district considered all these factors, including the outside mental health support, the input from those people, and it showed that student was still exhibiting major mental health issues and that they did not originally increase the offer of home hospital. So they kept it at the 5 hours to support student academically while at home. However, eventually outside staff continued to work with the student and shared that student was ready and could handle 1 more hour per week of academics through the home hospital instruction. And based on that information, the district did end up offering an additional hour, so 6 hours of home hospital instruction. But the issue was the parent didn't believe the 5 hours was appropriate. And the ALJ held that the student did not offer any testimony or expert opinion supporting that she could have tolerated more than the 5 hours at home. In fact, her mental health therapist, her outside support system was saying that she could not handle it. So it was only parent that was saying that she could at this IEP team meeting. The parent argued that the student needed to increase their hours to catch up academically and be able to graduate on time. However, the evidence supported that student was accessing her education while working on her mental health as well as her academics. So under the IDEA, Ojai was not required to offer student against all available expert mental health service additional service hours to ensure that the student graduated on a specific date. The next case I'm going to go over comes from Palo Alto, and it's a parent-filed case. The parent contended that the district did not make a clear written offer of FAPE because the offer for specialized academic instruction did not clearly state the duration, location, or frequency of the services. The offer in the IEP was for a separate class with a weekly duration of 390 minutes. Within the offer, the notes section indicated that the minutes were to be spent on academic planning and academic communications. However, there was no indication that these were in fact 2 separate classes or how long the student would spend in each of these classes. Through testimony, extensive testimony, it sounded like, the ALJ was able to determine that the academic planning class was taught by students' case manager and that due to alternate block scheduling, the schedule varied from day to day, but ultimately the class met for a weekly duration of 225 minutes. It was also determined that the academic communications class that was part of the offer was in fact a push-in speech service conducted by a speech and language pathologist and was 120 minutes per week. The ALJ held that the student prevailed on this issue because the offer was not clear, as it did not distinguish between the 2 classes, it did not state the minutes of each class, and it didn't state that the communication class was going to be subtracted from the overall offer of the total of the 2 classes. On the next slide, there's a second issue in this case where a parent contended that the district failed to assess the student for a specific learning disability. As you probably already know, California law allows for the 3 methods to determine eligibility, and the ALJ went through each of the methods: the severe discrepancy method, the response to intervention method, and the patterns of strength and weaknesses method. And based off his description or her description of the methods, they determined that the district did not use any of those methods. And the ALJ noted that the assessor was aware that the student had significant strengths and weaknesses from their standardized assessments that they conducted, but they did not analyze whether there was a significant discrepancy between the student's cognitive and academic assessments. Ultimately, though, even though they determined this, they held that the student, for the student by stating Palo Alto failed to obtain critical assessment information by failing to apply any of those methodologies related to the determination of a specific learning disability, though it had reason to suspect this area of disability. The last case I'm going to go over with you comes from Del Mar Union. It's another parent-filed case. Among a lot of issues in this case, the parent contended that the district failed to find student eligible under OHI. The psychologist had an original draft assessment report where she offered two different conclusions regarding OHI eligibility. At the IEP meeting where the psychologist presented the assessment data, the order described it as a robust debate over symptoms and behaviors that the student was exhibiting. The psychologist amended the final report to reflect only the analysis where a student did not meet eligibility under OHI. So she had two analyses, he had two analyses, one where the student met eligibility and one where they did not. The IEP notes indicated that they called this process refining the assessment report. The psychologist acknowledged that she was conflicted on the area of OHI eligibility and discussed this dilemma with other team members outside of the IEP meeting. In addition to this issue, there was an issue related to predetermination. And so that fact about outside of the IEP meeting discussion, that was brought into a different issue. After hearing all the testimony, the ALJ actually agreed with the ultimate recommendation of not meeting the criteria for OHI. And he agreed that that was accurate, but he also noted that acceptable refinement does not simply remove previously reported information to fit the IEP meeting discussion, especially when the subject matter, such as eligibility, is such a hotly contested item. Its deletion, the deletion of the qualifications was not a mere clerical error, and ultimately the district did prevail though, because the evidence and testimony, the parent was able to prove that student would not have qualified under OHI, and the district did prevail.
Okay, we have our last three cases. I know it's 12:38, so we might just go a couple minutes over, but I'll try to be a little bit quicker than I was planning to. This first case here, as you can see, it's a parent-filed case, Parent versus Bellflower Unified School District. And this case is about child find, whether or not you have to assess a kiddo when number one, a parent asks for assessment, and number two, they have a private diagnosis. But the theme of this case is whether or not you should deny a request for assessment when a student is absent a lot. And then the parent asks for assessment, but the student is struggling academically. What do we do when we have absences and academic struggles? Well, I always like to talk about the facts of the hearing in terms of just the hearing itself. This was a 3-day-long due process hearing where student had 3 different attorneys appear on their behalf, and it was presided over by the ALJ, Claire Yazigi. Let's talk about the facts of the student, though. This little kiddo was a kindergartner, and we were looking at the time period of March 2025, so just a few months ago, right, when parents said, hey, Bellflower, I have this private autism diagnosis, and I would like you to assess my child to see if they qualify for special education. Well, Bellflower received the parent's request for an assessment and said no. How did they do that? They did it through a prior written notice. That was good legally, right? When there's a disagreement over assessment, we respond with a PWN, and the PWN was actually very specific. Bellflower gave the parent 3 specific reasons why they did not believe that assessment was required. Number 1, their student had excessive absences. Now, in this case, what was excessive? Well, the student had 14 absences that were not excused, and then there were 9 absences that were excused. And we're talking about a 2-semester time period, so not the full school year yet. The second reason Bellflower denied it was that there had not yet been an SST meeting. And the third reason that Bellflower denied it according to Bellflower, this kindergartner, was functioning as a typical student for her age, according to the report cards and the teacher input. So basically, Bellflower said there was no reason to suspect a disability. And let's kind of take a look at the facts that the judge focused on, at least. Obviously, the law that was relied on in this case was child find. But the judge in this case had an interesting quote that I wanted to share with you. And this is the quote: either the parent's suspicion or the school district's suspicion may trigger child find. Now, again, this is may, right? I always get that question. If a parent is suspicious of a child, of a disability, does that mean that we have to assess? Not necessarily, but of course, a parent suspicion may trigger that child find obligation. Well, what was going on academically for this kiddo is, at the end of first trimester, by the way, this kiddo in TK was in a dual immersion Spanish program that was taught in Spanish for 90% of the day when this kiddo was English fluent. I thought that was kind of interesting, but at the end of the first trimester, she only knew 6 of 30 capital letters, 5 of 30 lowercase letters, and then knew the sounds of 35 letters. By the end of the second trimester, there was no improvement in these areas. So basically, the judge said, hey, Bellflower, you should have done an assessment. So Bellflower lost on that issue. But in this case, I thought what was interesting is that student had requested compensatory education for the time period where Bellflower should have assessed this kiddo. And the judge said no. The judge denied the request for comp ed and just simply ordered Bellflower to conduct an assessment for special education. So lesson learned on that case really is when a student has absences but is struggling academically, it may be risky to deny a parent's request for assessment. You may want to go ahead and go forward with that assessment. Let's move on. It's 1242. I have parent versus Fremont. In this case, the theme is uncooperative parents and how do we exit a student from special education if a parent will not allow assessment, right? The law says whenever we are going to exit a student, we need to have updated assessments, but what do we do if a parent won't allow it? The hearing in this case was 3 days long, and it was presided over by ALJ Cynthia Fritz. The parent was self-represented, so there was no attorney representing the parent. As you can see from the facts of the case, this case involved a high school boy. He had transferred to Fremont High School District in 9th grade with an IEP that had already recommended he be exited. So before he came to Fremont, this student was attending Cupertino Elementary District. They had just did a bunch of assessments, and Cupertino said, based upon all their assessments, psychoed, academic, and speech and language, student did not appear to be eligible for special education, right? So this is in 2024-ish. But then student transfers to the district, and even though he had been recommended to be exited, the parent had not consented. There was an IEP. The last agreed upon IEP was from 2018. So 2018 IEP, Fremont says, okay, I know that you recommended exit, but we have this IEP from 2018. So Fremont did the right thing. They implemented the last agreed upon IEP from 2018, even though the student had been recommended to be exited. Well, Fremont had an assessment plan. Parent did not consent. So in November 2024, Fremont did the right thing. They filed for due process on the right to assess. That's not even the case I'm talking about here. That was another case. Fremont filed for the right to get the assessment, and that hearing was presided over by ALJ Dan Center, who used to actually be an attorney representing students and families, and now he's an ALJ. Well, ALJ Dan Center ruled in favor of Fremont. He said the parent was not being cooperative. So ALJ Dan Center said, Fremont has the right to assess this kiddo. You got to make the kid available. So as soon as that decision was issued, which was April 2025, Fremont kept trying to assess, kept trying to assess. By the way, we're talking 9th grade, 10th grade. This kid was in 11th grade. 3 school years had passed, right? Well, parent would not make the student available. When staff would go in to assess the student said, I got to call my dad. Called the dad. The dad said, no, do not do these assessments. So as you can see, here we are with this case, parent versus Fremont, because what happened was Fremont, because they couldn't assess this kiddo, 9th grade, 10th grade, 11th grade, even after going to hearing and the judge saying you have to assess the kid, Fremont said, let's do a PWM. dear dad, we had this hearing. The judge said we get to assess your kid. You haven't made them available. So therefore, we are going to exit your child from special education by this PWN. Your child's no longer eligible for special ed. We know that because we have all these assessments that were done by Cupertino. And I think that they did a great job here. The judge didn't agree because Fremont said, hey, we're going to exit you in June of 2025. So Fremont had been providing the SPED services that whole time, but they said the next school year, which was going to be this boy's senior year, there was going to be no SPED. Parent sues, and as you can see here, the judge ruled against Fremont Unified and said, all these things, it's like the parent wasn't reasonable, the parent wasn't cooperative. But even when a parent isn't reasonable and isn't cooperative, you still should have had an IEP meeting, Fremont. And so the judge in this case did not like the fact that Fremont was trying to exit the student via a PWN. It may have been different if Fremont had had an IEP where they reviewed the Cupertino assessments, but they didn't do that. It's 12:46, so I can't talk about the last case. We'll look at the slide here, student versus Poway, a child find case. And the theme of this case is parent didn't share information with the district about the 5150s. This girl had been raped. She had been sexually abused. She was having major mental health issues, but no one ever shared this with Poway Unified School District. So then later on, when the family, when they end up in a due process hearing, the judge said, hey, you can't fault Poway Unified for not assessing your child when you didn't share the 5150s, the threat of suicidal ideation, or all these other mental health issues. So if you do have a parent at an IEP meeting or any other communications that's not sharing information with you about how their child is struggling, then obviously you don't have the information necessary to trigger that child find. And that's what the judge said. In this particular case, as you can see, the judge denied the request for 200 hours of comp ed. A couple times in the decision, the judge noted, hey, opposing counsel, which by the way was Henry Tavmasian, the opposing counsel, the counsel representing the student and the family, had in their closing brief, sometimes they asked for 200 hours of comp ed, and sometimes they had a typo and they asked for only 20 hours of comp ed, and the judge actually brought that typo up a couple of times. We went a couple minutes over our time and covered lots of cases about a variety of issues. We're going to end now by just talking with you about a couple of other workshops that we have coming up. The first workshop, Tillman, if you can scan ahead, is called Onboarding with Legal Insights. And this is a training that we're going to be doing down in Old Sacramento on the Delta King, that big, beautiful white boat that has the spinning paddle wheel. We're going to have at least 3 to 4 hours of legal topics in person. We're going to have some fun stuff as well. We're going to have some tasty bites, as well as a happy hour at the end of our event right there on the Delta King. And let's pray for sun and get away from these foggy days. 2 more announcements for you that Tillman's going to have, and we really thank you for being part of our day today.
We have 2 more Lunch with Legals on the calendar. So our first one is next week, next Friday, same time, Teams webinar. This is a Lunch with Legal special edition, so we're not going to be talking about OAH cases, but we're going to be talking about a topic that has just kind of been stuck in my head for the last few months. So I thought I'm going to research this, and then why not just share it with you all? And the question we have is, can you use AI to record IEP team meetings? So, like the AI transcription apps, very, very useful, but how do you do this legally? And there is a way, and if you come to our webinar next week, you'll find out how to do this. On February 27th, we're going to have our regular Lunch with Legal. It's going to be just like the case review today, and we're going to focus on the January 2026 cases. So if you want to stay up and current with your OAH cases, with these super hot legal topics, we've got the event on the Delta King, which is going to go into more depth on these topics. It's going to be a great time doing that in person. And if you want just these quick virtual bits, we're gonna do these 2 more Lunch with Legal webinars. Let us know if you have any questions about these cases, about these events. Let us know via email. You have the QR codes. We'd love to see you all. We appreciate all you coming so much for this Lunch with Legal, and we hope to see you for the next one. Thanks so much.